My body is starting to feel like it's shutting down.
Yeah, it's not shaking, you said shaking.
You said it was from Miss Benning. That's what I'm trying to determine.
I'm trying to pull it up for you
Okay.
so that I can get it to you.
She told the jury it was from the victim. It wasn't. And the moment that became clear, not to the audience, not to a journalist, but to the judge sitting directly in front of her, everything that followed was inevitable. This is the silent objection. Let's talk about what actually happened. To understand why this moment matters, you need to understand what a defense attorney's job is in the moments before cross-examination begins. Before you stand up and challenge a witness, before you imply to a jury that someone's testimony cannot be trusted, before you use a document to suggest a person was in a particular state of mind, you verify your evidence. You verify your source. You verify who sent what to whom. That is not a courtesy. That is a professional obligation. And in this courtroom, on this day, that obligation was not met. The case involved a witness on the stand, a doctor. The defense attorney, identified in these proceedings as Miss Hollage, was conducting cross-examination. She was attempting to challenge the witness's conclusions by suggesting that the subject of the case, a woman, had disclosed information about drug use. Specifically, the attorney wanted to establish that this woman had communicated something about her physical state, about her body shutting down. The implication being that any symptoms, any condition, any account the doctor had formed was compromised by that undisclosed information. To support that framing, Miss Hollage pointed to a text message, a specific text message, and she attributed that text message to a specific sender, Miss Benning. The doctor engaged with the question. The jury heard the question. The testimony proceeded. And then the judge looked more closely at the document. Here is where you need to understand what a text message record looks like when it has been extracted from a phone as part of a legal proceeding. When law enforcement or a forensic analyst pulls text messages from a device, the resulting document contains metadata, data about the data. It records a sender number, it records a recipient name, it records the timestamp. It is a chain of custody document, and reading it correctly is not optional. The sender column tells you who wrote the message. The recipient column tells you who received it. These two things are not interchangeable. The attorney, by her own eventual admission, had misread that document. She had looked at a sender number beginning with 501 and a recipient listed as Nigel, and she had concluded, before walking into that courtroom, that the message had come from Miss Benning. It had not. According to her own staff, when she stepped aside briefly to consult them, the message came from Niga, a different person entirely. The foundation of her cross-examination had been built on a misidentified sender.
It did not say Jade Benning. So when I saw sender 501,
Okay,
which is,
well, let me ask you, are you acknowledging you're now mistaken?
I don't know that. I can say that she's right because it does say sender's name, Niger.
But here is the part that makes this proceeding worth examining carefully. When the judge pressed her, gently at first, then with increasing directness, Miss Hollage did not simply say, "I was wrong. I misread the document. I apologize to the court." She did something that attorneys should recognize immediately, and that every one of you watching should file away for future reference. She began negotiating the terms of her own admission.
So what she shared with me that it was in fact from Nigeria. However, we have several other messages where she does in fact do the same drug. So we can come back.
You're jumping way ahead of me.
Well,
The
if
question you asked the doctor, is that wrong?
let me say this.
She said, "We have other messages." She said, "The same drug use appears elsewhere." She said, "If the jury hears I was wrong about this one message, I need to be allowed to introduce the others." She was not correcting the record. She was bargaining for the right to continue the same argument through different evidence. And the judge, to his considerable credit, did not permit that negotiation to proceed unchallenged. This is the midpoint of what happened in that room. And it is worth pausing here, because the next exchange is where the real story begins. The judge made his intention clear. He was going to bring the jury back in. He was going to instruct them that questions asked by attorneys are not evidence, a standard, procedurally sound reminder that courts routinely offer. And he was going to tell them, specifically, that the question implying the text had come from Miss Benning was not supported by the document the attorney had referenced. This is called a curative instruction.
I'm trying to protect the
I
record.
said, I'm gonna bring the jury in and instruct them that questions aren't evidence, and that
That's
your
what we
question about, to the Dr. Malayla, about Miss Benning generating a text that she was starting to feel like her body was shutting down, did not come from Miss Benning. You now agree to that, right? You agree the text did come from Miss Benning.
It is one of the tools a judge has to correct the potential contamination of a jury's understanding when improper or inaccurate information has entered the courtroom, even indirectly. Miss Hollage objected, and the argument she made in objecting is the argument this channel exists to examine. Her position was this: the court cannot comment on the evidence directly. If the state wants to correct the record, the proper mechanism is to recall the witness, bring the doctor back, ask her the relevant questions, and allow the jury to assess the new information through testimony. Anything else, she argued, would make the jury believe she had been deliberately misleading them, that the court correcting the record without giving her an opportunity to introduce additional evidence would damage her client's case in a way that could not be remedied. She is not entirely wrong about the procedural principle. Courts are generally cautious about judicial commentary on evidence. The role of the judge is not to become an advocate. A judge who steps into the substance of the facts, who tells the jury which pieces of evidence to believe or distrust, crosses a line that the appellate system takes seriously. There is genuine legal doctrine behind the concern she raised. But here is what she did not address, and here is what the judge kept returning to, calmly, repeatedly, with the particular patience of someone who has heard every variation of this argument before. She had already put the contaminated information in front of the jury. The question had been asked. The implication had been made. The jury had heard a doctor respond to a question premised on a text from Miss Benning. That premise was false. The text was not from Miss Benning, and the attorney had used it anyway. Not out of malice, she would insist, but out of error, out of a failure to verify what her own staff had prepared. The judge said it plainly. You misunderstood the text. She said, "You're right." 3 words, and then she kept on.
We can clear it up and I can talk about the same drugs and
I'm
the
not
different
dealing with
texts.
the others and what are the witnesses. I'm dealing with, were you wrong on who generated this text?
I was, but that text did not come into evidence. The question was...
Your question included the text.
She argued that since the objection to the original question had been sustained, meaning the jury had technically been told not to consider it, there was nothing to correct. The judge disagreed. He pointed out that she had asked the question again, differently, that the second version had not drawn an objection, that it had been answered, and that the final question she had asked, whether knowing the subject was taking Adderall to the point of shutting down her body would have been contrary to her history, had been answered yes by the doctor, without objection, while the jury was present. The information was in the room.
Sustained did not come in. Then your final question after the mushrooms and everything else was, if you knew that she was taking Adderall to the point of shutting down her body, would that been contrary to her history? She answered yes. They didn't object. So the jury heard all that.
And they can bring the doctor back and say something different.
This is the moment worth slowing down for, because the attorney's entire argument rested on a distinction she was unable to maintain. She kept insisting the misattributed text had not come into evidence. The judge kept pointing out that the question derived from it had.
Then why are we talking to the jury if there's no evidence?
Because you brought it up and misunderstood what your staff gave you.
So that means that the state has a right to bring that witness back up. That is the way that that is handled. It's not for the court to then impeach me.
Questions are not evidence. He acknowledged that. He had told her that from the beginning. But a question that plants a specific, false, factual premise in front of a jury does not disappear simply because the underlying document was never formally admitted. The jury heard it, the doctor answered it, the implication landed. She said, "I did not know the text was wrong."
You misunderstood the
You're
text.
right, but the court sustained the state's objection.
Not the third time.
The third time, if my question is wrong, the proper thing for them to do is to bring that witness
But that
back.
message got to the jury. So how would I explain to the jury what question or what information we're talking about?
Your Honor, that's not for you to do.
She said she did not know that. And that is the sentence that stays with you when you read this transcript carefully. Because knowing and not knowing are not the same as verifying. An attorney who presents information to a jury has an obligation to know what she is presenting, not approximately, not based on what her staff told her, not contingent on pulling it up on her computer later to double check. She presents it, she owns it. And when it turns out to be wrong, the question of whether she knew becomes significantly less important than the question of whether she checked. The prosecutor, for her part, offered the sharpest line of the entire proceeding. She said, she's supposed to be ethical, follow the rules, and not lie to the witnesses. The judge's response was careful, precise. He said, she wasn't unethical. She was wrong about who sent the text. Read that sentence again. The judge drew a line between dishonesty and error, between deliberate misconduct and professional failure.
No, Your Honor, but she keeps talking about us impeaching her. She's
I
supposed to be
know.
ethical, follow the rules, and not lie to the witnesses.
Okay, so
She wasn't unethical. She was wrong about who sent the text.
The jury was instructed. The doctor was gone and could not be recalled in time to address the specific exchange. The proceeding moved forward to the next witness, and Miss Hollage retained the right to argue, in whatever form remained available to her, that other evidence supported what she had been trying to establish. But the record was what it was. The judge had been required to step into the middle of a jury trial and explain to 12 people that a question they had heard, one that had shaped their understanding of a witness's testimony, had been built on a misread document, that the sender was not who the attorney said it was, that the premise was not what the attorney had represented it to be. Here is what this proceeding teaches, and I want you to hold on to this, because it is relevant to every one of you who will ever sit across a table from an attorney, hire one, or watch one stand up in court on your behalf. Evidence verification is not a clerical task. It is not something you delegate to staff and accept on faith before walking into a courtroom. When an attorney represents a fact to a jury, even in the form of a question, even without formally introducing the underlying document, she is making a promise to that jury about what the record contains. If that promise turns out to be wrong, the mechanism for correcting it is not private. It is not quiet. It happens in open court, in front of the people whose understanding of the case has already been shaped by what she said. The attorney in this courtroom did not intend to mislead anyone. The judge said so directly. But intent is not the standard by which juries assess the information they receive, and it is not the standard by which the legal profession assesses the conduct of its members. You are responsible for what you put in front of a fact finder, all of it, including the parts your staff prepared. The text said her body was starting to feel like it was shutting down. The attorney used those words to suggest a particular truth about a particular person's state of mind. The text was not from that person. And in the end, the only thing that shut down, quietly, in a bench conference, while the jury waited outside, was the argument that it was.